Commissioner, I think we're ready when you are.
Perfect. Well, first off, I want to thank everybody for joining us today for the New Hampshire Insurance Department's discussion on the Federal No Surprises Act. I'm joined by a number of my colleagues today, including DJ Betancourt, the Deputy Commissioner here at the department, Tyler Brannon, the Life and Health Director here, Attorney Michelle Heaton, who's our Health Law and Policy Legal Counsel, Keith Nyan, our Consumer Services Director, and Tiffany Fuller and Andrew Demers, who will be helping with our Q&A session. Just a little bit of basic background. In December of 2020, U.S. Congress enacted the Federal No Surprises Act, or NSA, which went into effect January of 2022. This legislation contained provisions designed to protect consumers from surprise medical bills. The provisions create requirements that include cost-sharing rules, prohibitions on balance billing, notices and consent requirements, and requirements related to disclosure about balance billing practices. In December, this department released a consumer-focused frequently asked questions document, which was designed to answer some of the most likely consumer questions. Today's webinar is another effort that we're undertaking to provide consumers, healthcare facilities, and providers information on the requirements of the Federal No Surprises Act. In today's program, Deputy Commissioner Betancourt will give a brief overview of the history of New Hampshire's balance billing law. Attorney Michelle Heaton will highlight some of the differences between the federal and state dispute resolution processes. Tyler Brannon will give an overview of our legislative strategy moving forward. And then we'll leave some time to take your questions regarding the No Surprises Act. If you do have a question at any point during today's presentation, we ask that you write them in the comment section. From there, Andrew and Tiffany will organize them and provide them to us at the end of the session. We encourage you to be liberal with your questions, and we'll get through all of them that we can. An effort to bring, near 100 people together today. Hopefully we can all leave with a little better understanding of the NSA. To begin the presentation, I'd like to introduce Deputy Commissioner DJ Betancourt, who will provide a brief overview of the history of New Hampshire's balance billing law. DJ?
Thank you so much, Commissioner, and thank you everyone for joining us today. So New Hampshire has really been at the forefront of protecting consumers against surprise bills. And the state's motivation for pursuing that effort is one that hopefully all of us can share, and that's consumer protection. According to the American Journal of Public Health, nearly 67% of personal bankruptcies in the United States are tied to medical expenses. And that process is obviously devastating for individuals and families. In 2018, at the urging of Governor Sununu and the New Hampshire Insurance Department, the state legislature, with the leadership of both parties, passed legislation prohibiting out-of-network anesthesiologists, pathologists, radiologists, and emergency physicians from surprise billing a commercially insured patient when the care was provided at an in-network hospital. Our system here in New Hampshire has worked incredibly well, and we believe that it is a model for other states to follow. In fact, to date, we have had no appeals come to the department, which suggests that the process that we have put in place has successfully not only removed the patient from the dispute over a medical bill, but it has also fostered the ability for the provider and the carrier to reach an amicable agreement. Now, the newly passed No Surprises Act, a federal law passed and went into effect the first of this year, will extend those protections and end the practice of surprise billing in most aspects of commercial insurance. Between the state law and the federal No Surprises Act, it will cover patients with either a fully or self-insured health plan and will have those protections extended to those patients. The No Surprises Act, and obviously we'll hope to clarify some of the confusion around it today, but much like the whole world of insurance can be complex, and the New Hampshire Insurance Department has committed itself to being there for consumers every step of the way. As the Commissioner mentioned, we have additional informational documents on our website that explain the details of the law and its impact on insurance companies, healthcare providers, and patients. But we encourage members of the public who have questions to please contact our consumer division. They are available to help with any questions and provide guidance, and they can be reached at 603-271-2261 or by email at consumerservices@ins.nh.gov. With that, I want to thank you for attending today's event, and I want to share with you that this is going to be part of a monthly webinar series that the department plans to host. And so next month, we're going to be focusing on long-term care insurance and the challenges and dynamics facing consumers in that market. So we obviously hope that you'll join us for that event as well. But with that said, I'll turn it over to Michelle and Tyler to begin today's presentation.
Great, thanks, DJ, and thank you, Commissioner. If successful, I am going to share my screen, which is a PowerPoint presentation, and take people through this. And hopefully you can see a slide that has a title page with some nice pictures on it. Just to begin, we want to clarify what we're talking about when we're talking about balanced billing. The first is it's a healthcare provider charge that is not paid for by the insurance company. This is beyond, though, your regular cost sharing. The member still pays their deductibles or co-insurance or co-payments. But typically a balance bill when you go to an in-network provider is the difference between an allowed amount and the provider charge. The allowed amount is determined in that contract between the insurance company and the healthcare provider. Some insurance coverage provides maximum amount of benefit when you go to an out-of-network provider, and that could be considered a balanced bill as well. In other words, the insurer will say, well, we'll pay the healthcare provider up to a typical amount that would be paid for a service, and then the provider may balance bill the member for the additional amount. But again, that's when you go to an out-of-network provider where there is no agreement ahead of time between the insurance company and the healthcare provider about how much the provider is going to receive for payment in full. When you do go to an in-network provider, we actually have an insurance law that applies to those situations. Under a section of the insurance statute called Provider Contract Standards, there is a prohibition that from the provider balance billing the member for more than regular cost sharing. This is a requirement that is needed to go into the contract between the insurance company and the healthcare provider. The insurance company is actually responsible for enforcing the contract terms. In turn, the insurance department is responsible for making sure the insurance company has these terms in their contract. That being said, the insurance laws we have in New Hampshire, like any other state, typically apply to just the fully insured business. If you're under a self-insured employer that is administering your benefits through a health insurer in the state, such as Anthem or Harvard Pilgrim, typically our insurance laws don't apply. I will say, though, that most of the time the provider contract between the healthcare provider and the insurer is the same for both fully insured and self-insured employers and the members that are covered. So this prohibition on balance billing beyond your regular cost sharing typically would apply, but we'd have no regulatory oversight in those cases where the member is under a self-insured employer. The 2018 law did include protections when the patient goes to an in-network hospital or an ambulatory surgery center and is seen by one of the 4 specialties listed here. So these are providers you may not have known were even going to be involved in the care. You may not have checked to see if they were going to be in-network, and you certainly didn't make arrangements so that they would only see an in-network provider. And that's why these balance billing or surprise billing laws were passed in New Hampshire, is to protect a member in these scenarios. And indeed, most of the time when you receive a balance bill at an in-network facility, it's likely to be from one of these 4 specialists. Provider and insurance company must determine what a commercially reasonable allowable payment is going to be under the New Hampshire law. Balance billing is prohibited by the provider, and the member cost sharing is calculated from that allowable payment amount, the commercially reasonable amount, not the provider charge. And as you can imagine, when the insurance company is negotiating a lower reimbursement level to the healthcare provider, and your co-insurance or deductible is based on that lower amount, that could be a significant savings versus having co-insurance or deductible applied to the provider's charge. So this is a consumer protection that avoids the exposure of those high charges that could exist with an out-of-network healthcare provider, and makes sure that people are protected and get that protection consistent with their health insurance that they purchased. The federal law that became effective in January this year is a little bit broader than the New Hampshire law. It includes protection from surprise balance bills by those out-of-network 4 specialties that are under the New Hampshire law, or virtually any other provider that might be out of network when you go to an in-network facility. The federal law also includes out-of-network hospitals when you receive emergency services. That includes out-of-network air ambulance providers. Note a warning, it does not include ground ambulance providers, so you could still receive a balance bill without the same protections if you take an ambulance transport that doesn't fly. One of the other differences with the federal law is that it makes use of this qualifying payment amount methodology to determine the payments to the out-of-network providers and the associated member cost sharing. The good news is both the federal law and the state law keep the member or the patient out of any dispute about the actual amounts that are going to be paid to the healthcare provider. As a reminder for probably most of the people on the line, the insurance is regulated at the state level. State insurance departments must be given authority, usually through their legislature, to enforce federal laws. Two of the best examples of that are what we refer to as the Parity Act of 2008, as well as the Affordable Care Act. These are both federal laws that make a number of changes to insurance. The New Hampshire legislature acted to pass legislation to give the New Hampshire Insurance Department the authority to enforce these laws. So what's going on? You've got a federal law related to balance billing. You've got a New Hampshire law that already existed and has for several years. Well, we're coordinating with CMS about the enforcement of those two laws. And state laws are not preempted, generally when they are as consumer protective as the federal requirement. So we have coordinated with CMS. We figured out who's on first for each provision, and the insurance department will continue to protect consumers and resolve disputes for the specialties that are listed in the New Hampshire law. We will continue to play that central role, and we have an interest in protecting consumers going forward. The requirements beyond state law are enforced by the federal government. And I will say everything that I've been talking about relates to commercial insurance, but the No Surprises Act does apply in some cases beyond your commercial insured population. And one of the key areas for that is for providers to include good faith estimates for people who are uninsured. At this point, I'm going to transition to Michelle, and she's going to talk a little bit about the differences between the dispute resolution process at the state and the federal level.
Hi, everyone. So at the federal level, there's an independent dispute resolution process, and this process is available for when providers and facilities cannot agree with health plans regarding the out-of-network rate. And this is a different process than the process that a non-insured person might use if they have a dispute with a provider about how they were billed for something that they had a cost estimate for. So I did want to clarify that these are two separate processes, but this is the type of process that would be used when in situations where there's surprise billing. So this applies, the federal process is going to apply whenever there is no state process or the state process is inapplicable. So as Tyler was saying, for those 4 specialties, New Hampshire will continue to use its current balance billing process to resolve disputes. However, for any other specialties or in other instances where balance billing is prohibited, but it's not covered by the state process, the federal process will apply. It's also applicable to self-insured plans. So what is this process? This process is pretty strict in that you have to make a request for the IDR process after the 30-day open negotiation period has concluded. So once the dispute arises, you have a 30-day open negotiation period. Once that 30 days is up, you have 4 business days to actually initiate it. And if you miss those 4 days, then you're not able to use the process. So there is some pretty strict timelines with the federal process. The federal process uses certified IDR entities. So if you go to the federal website, then there's a federal website for No Surprises Act, and it has a lot of this information and more information about how to access the IDR process in all kinds of templates and forms. They have already certified a good amount of IDR entities. So those would be the entities that are going to be hearing these disputes. So each party, once the process is initiated, has the ability to submit what they deem to be the appropriate offer for this disputed claim. And you can bundle claims as well. So when they submit that claim, they're required to pay the fee for it. And each entity has set its own fee, but those fees generally range between $200 and $500 for a single claim and $268 to $670 for batch claims. So each party would pay that fee when they submit their offer, and then the prevailing party is refunded. So unlike the New Hampshire system that we're going to get to in a second, this system does require the parties to submit a payment. And then once those offers are submitted, the IDR entity selects one of the offers, and that decision is binding on the parties. Next slide, please. So how does that IDR entity make the decision? There's a presumption that the QPA is the appropriate out-of-network rate. So that is kind of the base where everything starts. Now, if party can submit credible information that clearly demonstrates that the QPA is materially different than the appropriate rate, that's where you have some wiggle room. And below are the factors that the IDR can consider and the factors that they cannot consider. So some of the factors that can be considered in determining whether the QPA is materially different from the appropriate rate are level of training experience, quality outcome measurements, market share, acuity of the patient or complexity of furnishing the service, teaching status, case mix, scope of services of the facility, a demonstration of good faith efforts or lack thereof of the parties to enter into a network agreement. The big thing is the factors that cannot be considered are the usual and customary charges, the charges that would have been applied had there been the no prohibition against balance billing. And another thing that cannot be considered is the rate payable by a public payer such as Medicare. Next slide, please. So those are the factors that the federal IDR process uses. The New Hampshire process is a little bit different. So the New Hampshire process, like we said before, only applies to commercially insured plans and to healthcare providers that are performing anesthesiology, radiology, emergency medicine, or pathology in an in-network facility. So in those situations, the New Hampshire process is used. And instead of going through, instead of there being a default of the QPA, instead reimbursement is limited to a commercially reasonable rate. And the commissioner is the one who decides what is the commercially reasonable rate. So in order to get this process started, either one of the parties can petition the department for a hearing after they have been unable to resolve the dispute. So they should be making good faith efforts to try to resolve the dispute between themselves, and this process really comes into play when they're unable to do that. And to make sure that they are trying to resolve it themselves, the commissioner may require the parties to mediate prior to scheduling the hearing. And this is a hearing, like many other hearings, that is open to the public. And it would follow the same hearing procedures as those outlined in our administrative rules. Those are Administrative Rules INS 200, goes through all of the hearing procedures. In particular, we do have special rules for this process, and that is the INS 208 series of rules. And in those, there are specific filing requirements that you would have to follow in order to be able to request a hearing. And some of the filing requirements are when you're submitting your petition, you have to put what you believe the commercially reasonable rate is, explain any evidence or methodology you use for asserting that fee is reasonable, detail any relevant facts relating to the billing code, and you also have to detail the efforts that the parties have made to try to resolve the dispute before coming to the department. So those are some of the filing requirements, but I would suggest anyone look to the INS 200 series for all of the particular requirements. And just to give a broad overview, the way hearings typically work at the department is there would be a request for a hearing. The hearing gets scheduled and it's very much like a court proceeding. Each party has the opportunity to present evidence and witnesses. A hearing officer would take in all the evidence and write a proposed order. That proposed order must be issued within 30 days of the hearing. And then after that order, the commissioner would have the final say and would weigh in on the proposed order. And there is a mechanism in between that if the parties do not like something that's in the order, they can request an opportunity to argue points of law in front of the commissioner before that final order is issued. However, with these hearings for the dispute resolution process, the commissioner's decision is final, and it's not like other hearings, like disciplinary hearings, that are appealable to the court. For the purposes of balanced billing, the commissioner has exclusive jurisdiction to determine the commercially reasonable rate. And that decision is based on the evidence being submitted by the party in the hearing. And that is what the commissioner's decision is based on. So it really comes down to what the parties are presenting as evidence in the hearing. And
Thanks, Michelle. Just to say a little bit about New Hampshire's advantages in this area. The first one is just our experience with balanced billing protection laws. We've had our laws on the books now for several years. We worked pretty hard before that law went into effect through a legislative study committee. And that study committee gave us the chance to listen to the different parties that would be involved in the balanced billing disputes, what had taken place before that, and what type of solution made sense for New Hampshire. One of the other advantages is that we generally have broad insurance networks. A lot of that is driven by the market, but if you look compared to other states, you'll see very few hospitals that are out of network in New Hampshire. And in general, we don't have those types of narrow networks that might lend themselves to a greater frequency of out of network providers. Along the same lines, we have very detailed network adequacy requirements. The insurance carriers actually submit their networks with all their providers to the department. We run that through an algorithm to make sure that you can access services within a reasonable time and distance standard. And we can flag any deficiencies between the rule and between the carriers' networks based on actual services provided in New Hampshire. We are a leader in New Hampshire when it comes to price transparency and use of claims data. The state does have an all-payer claims database known as New Hampshire CHIS, which is an anonymous set of claims data and tells us a lot about the price of healthcare services. In doing so, we've been able to provide good information in the public domain so that people have a better sense of whether or not reimbursement is fair and reasonable. And we also have, it's worth saying, a very local and balanced approach to resolving problems. New Hampshire is a small state. We all tend to know each other when you work in the industry, and we work closely around some of these problems, whether they be legislative or other means of resolving issues. And that is reflected, I think, both in our balanced billing law, as well as in how little disruption passing those laws made to our networks. One of the challenges with any big policy decision that comes down to reimbursement levels with healthcare providers is that every party is going to look at whether or not they're better off or worse under the default, and whether or not it's worth putting together a petition to the department. The last thing you want to do is pass legislation that results in a whole bunch of providers leaving the network and then petitioning to the department. Moving forward, there is a consensus that we want to continue to protect patients from surprise bills. That legislative committee that worked before New Hampshire passed its bill, that was a consensus there. And the good news is both under the New Hampshire law and the federal law, the patient is protected and kept out of disputes. We have submitted and requested legislation to maintain local control over balanced billing protections, and that's known as Senate Bill 287. That would continue to have the insurance department playing a key role in making sure that our insurance carriers pay those out-of-network providers for the services under these circumstances, that we interpret the insurance laws to protect consumers, and that we resolve disputes if any come up. We also want to make sure that our insurance carriers maintain robust provider networks and comply with network adequacy requirements. In general, as I mentioned before, most of the providers are in network already. We're not trying to solve a problem with most of them being out of network. We just don't want to disrupt that sophisticated negotiation process between insurance companies and healthcare providers with a major policy change. The other thing we want to do, make sure we do, is control healthcare costs and premiums. It's pretty easy to protect consumers if you don't concern yourself with what kind of impact it's going to have on health insurance premiums. But we've been able to do that through our balanced billing law without putting upward pressure on healthcare costs and premiums. And hopefully we can continue to do that in the future. We will also prioritize transparency of the process we use to resolve disputes and healthcare prices. The insurance department has no intention of slowing down the amount of information we produce in the public domain around healthcare prices. A lot of that is available through health costs, but we also make downloadable sheets for industry so they can see what the reimbursement levels are by CPT code and understand what is considered commercially reasonable, competitive, and fair in New Hampshire. And then finally, we will continue to maintain what we've put up in terms of the FAQs around the No Surprises Act and balance billing in general. As things develop, as new questions come up, we'll continue to play a key role in providing information in an objective way to consumers and providers in the health insurance industry. That's the end of the presentation they had. That's the contact info for myself and for Michelle. And at this point, I'll pass it back to the commissioner, or I think we are taking questions from people, and perhaps Tiffany or Andrew are managing that.
Yes, if you have a question, please type it into the chat box, and Tiffany and myself will be happy to address those and direct the correct person to answer them. So please type them in the chat box if you have any questions.
And if not, we'll give you 34 minutes of your life back.
Well, Tyler and Michelle, you clearly have done a fantastic job here. We have no questions, so it looks like you've covered it quite thoroughly. But we do have a few coming in now. Andrew, go ahead.
Okay, the first question is asking, does this apply to private practice behavioral health?
So if I to interpret the question, it would have to be at a sort of an in-network facility. So you're talking about kind of an out-of-network private practice behavioral health provider performing services at a in-network facility, or potentially even on an emergency basis. So I think the short answer is most likely, unless there's some special circumstances that perhaps the question is thinking about kind of an out-of-network private practice outside of an in-network facility.
Thanks,
Okay, next question is, will you be providing the good faith estimate process in a separate session?
So the good faith estimate process, at least as I referred to in my part of the presentation, was for the uninsured. And being that the insurance department regulates insurance carriers, the good faith estimate process is going to be managed by the federal government, and directly so with healthcare providers. There are requirements for insurance carriers to provide information on the prices of healthcare services. And in that case, then we do tend to be enforcing the federal laws with insurance companies.
Okay, the next question is, does this affect ERISA and individual market plans?
So this is a reference to ERISA, and that is targeting the sort of self-insured employers and the members that are covered under those self-insured employers, even though their benefits are administered by an insurance company we might all be familiar with, like Anthem or Harvard. And the federal law does apply the protections to the self-insured employers and the people who work for them as well. That's one of the biggest changes with the No Surprises Act.
Okay, the next question is regarding dental providers. I would like to check on the dental providers that are part of ACA essential benefits. Has the state looked at these providers with the dental carriers and health providers as well?
So that's a good question. So you're talking about dental providers providing essential health benefits and what circumstances they might be pulled into the No Surprises Act. I have a good answer for that yet. It probably could happen, but it just hasn't come up on the radar yet. Michelle, do you have any thoughts about that?
One thing to keep in mind is that the No Surprises Act does not apply to accepted benefits. So separate dental plans are not affected by NSA. But to the extent they're part of the essential health benefits, they would be subject to those protections. But again, those protections relate to emergency out-of-network care and care provided by an out-of-network provider at an in-network facility. So it's a little bit different. I mean, it's less likely you're going to have a situation where there would be a surprise balance bill, because if you have a dental emergency, you're not going by ambulance to a facility that you don't have control over. You know, usually you're going to go to your dentist that would be in network. But I suppose there is a scenario where this could come up, and assuming it's part of the essential health benefits and part of a major med plan, then there would be some protections in place.
The next question comes from someone at a mental health center who asks, if you don't provide any out-of-network services, does the No Surprises Act have an impact on our center, a mental health center?
Not through the commercial insurance side. The only other requirements might be potentially the good faith estimates or some of the other requirements for disclosure and notification to consumers. But it's most of the No Surprises Act is targeted when you receive out-of-network care at an in-network facility.
Okay, I think the next question was addressed, but I will read it. It's private practice mental health providers are not considered facilities. Does it still apply?
It would apply to any providers or facilities. So if you're a provider and you provide that's out of network and you're providing emergency services, then it would apply to you. But I hope that I answered it.
Are there any other questions? Feel free to please type them in the chat box.
Well, I want to thank everybody for participating today. I'm excited to see that something north of 140 people signed on for what I think is our inaugural webinar related to something that's happening at the department. We plan to schedule more of these, especially when we have relevant bulletins or notices that go out, potentially important legislation. And so you may see in future press releases an invitation to attend an event like this. This is part of our effort to have transparency, but more importantly, to benefit from hearing from all of you folks when appropriate. So thanks everyone for the time, and I think we can sign off.
I think we had one last question come in about ground ambulance, and it does not affect ground ambulance.
There we go. That was an easy one.
I even knew that one, Michelle. All right.
Thank you all very much. Have a great rest of your day.
Thanks, guys.